Until I looked at myself in the mirror one day and I was disgusted with what I saw. So I said, you got to make a change, man.
It's all about fun, laugh, and get through life. That's what it's all about.
I find you have everything to gain with Frank, and without him, everything to lose.
Then I'm gonna lay you down, just like the bridge over troubled water.
Hello and welcome to the show tonight. How's everybody? I hope you're doing well. And let me bring in my co-host now, Dr. Vanessa de Danzine. Hello, Vanessa.
How are you, Lottie? How's everything?
Oh, well, you know what? I'm very excited about the topic tonight. Who will get your money? I'm giving all mine away, so I'm not worried about who's getting mine or whatever. But we have two great guests coming on to talk about planning your estate and wills. And also we have our guest coming on to talk about insurance and long-term care. So why don't we bring our guest on at this time, Miss Vanessa?
Yes, I'd like to welcome Miss Lisa Gaspero. She's an attorney at law in Chicago, Illinois for Gaspero and Gaspero PC, and she specializes in estate planning and taxes. So welcome, Lisa.
Thank you so much. I'm so happy to be here. Thanks, guys, so much for letting me be on this show.
Well, Lisa, I'm so glad you took the time to come because we need to hear this information tonight because of everything that goes on. I'm tired of people fighting over everything. So could you please take us through the steps of, having a trust against having a will, and what is the steps that we should take?
Absolutely. So, we work so hard to create our estate and develop our assets and care for our loved ones all lifelong. The greatest thing that we can do is make sure that we ensure a smooth transition after passing. And it's not just actually death we're talking about. We're talking about if we ever become incapacitated. So one of the greatest things we can do is ensure that smooth transition. And a lot of people assume that just because they're married or they have children or they have loved ones around them, that it'll be an easy process when something or if something should happen, when in fact that's not the case. There are very strict rules that are applicable during this time that will really affect that type of transition. So one of the first things that can be done is we want to make sure that we have documents in place. Now there's different types of documents that we would create for somebody. One of the most important things is, now I'm speaking from Illinois law, but I am able to say that across the country, most states are very similar in this regard, and I do work with co-counsel in other states in this regard. So in general, if you own a house in most states, that's going to be sufficient to trigger what we call the probate process, which is a court process. Now, the probate process will be triggered if someone passes, if you pass owning a house, okay? If you own a house, when you pass, that means that there's going to be a very regulated court process that takes a long time. And that is true even if you have a will. And so what happens is when we do our planning, we want to kind of try to do everything we can to avoid being in that court process, okay? Mm-hmm. So what does that mean? That means getting with an attorney to talk about getting your documents in order. And some of the important things you can think about are just think about who's in your life, who's close to you. And if something would happen to you, if you became either disabled, unable to make decisions, or if you passed on, who close to you would make financial decisions for you? Things like paying your bills, caring for your loved ones, taking care of any financial needs of your children, who would be filing tax returns for you, making sure that you get your benefits from work, all of those things, making sure that, God forbid you pass on, making sure that your loved ones get the money that they need that you've worked hard for all your life. So these are really important decisions. So I like to call that grouping of people your financial representatives. But financial representatives really means your trustee, your executor, and your power of attorney for property, okay? And it is fairly similar in most states, okay? So these are the people, again, that you're appointing during your lifetime now to make these decisions for you. And if we do things properly, we don't have to go through a court process, which can be extremely expensive and time-consuming. Do you know that in Chicago and in Illinois, when the coronavirus pandemic started, that courts were closed for several months and people didn't have normal access to the court system. And during that time, people passed. And the problem was they, if they didn't have their affairs in order, they needed to have documents from the court in order to get life insurance proceeds for their loved ones or to access benefits. And literally we couldn't do anything for them for a while. They had to wait, and it was very much a financial hardship for many people. Right. So doing anything you can to plan in advance, to keep it out of the court system, to make sure that you have your affairs in order, it not only makes it a very smooth transition for your loved ones, but the other thing too is it respects your dignity. The other thing about planning in advance with advanced documents, will, trust, power of attorney, those documents that can be prepared for you, is that if you become unable to handle your own affairs, if you become incapacitated, if you don't have those documents in place, what can happen is there'll be a court proceeding called a guardianship or a conservatorship. And in essence, what happens is that the court will be handling all of that. And it's not a sealed matter, it's a matter of public record whenever those proceedings are going on. Most people don't want the whole world to be able to see their private matters if they're incapacitated. So having these documents in effect means that we're doing it outside the court with people you really trust, if that makes sense.
So Lisa, question. If you own a house, right, should you have the house put in a trust, or should you just have the person's name put on the deed?
All right, so let's talk about that. That's otherwise known as joint tenancy. The problem with joint tenancy is you can't halfway give to somebody, right? You give 100%. So if you put someone's name on your house or on your bank account or anything you own, it becomes 100% theirs as much as yours. And the significance of that is that if that person whom you put on your assets, let's say they go through a divorce or they get sued by somebody, or, who knows, anything could happen, they become disabled, those assets under the eyes of the law that are held by joint tenancy are equally theirs. And so, that's generally not a good way to handle estate planning. The other tricky thing about doing that is, depending on the order of, God forbid, depending on the order of death, what happens is you can have something unintended happen where, let's say I decide I'm going to put my best friend on my house because I'm close to that person. What happens is, or let's say I decide to put my daughter on my house, right? Let's say my daughter's married. I put my daughter on my house as a joint tenant. I die, and then my daughter dies. It actually can go according to her estate, which is her spouse, which may or may not be what people want, So there's not, it is much easier, believe it or not, to address it right away, to talk to a qualified attorney about exactly what you intend. Things that should be thought about are not just, we talked a little bit about financial representatives, who's going to be, handling, paying your bills, filing your taxes, making sure distributions are made to your loved ones, your beneficiaries. But other things to think about are, where exactly do you want your estate to be going? So in other words, we all think about sort of the first person next to us. Well, I want it to go to my child, or I want it to go to my spouse, or I want it to go to my best friend or my sibling, or, those are all really important things. Right. But we also ask down the line, well, what if that person's not living? What if that person's not living? And you'd be surprised everybody has very strong feelings about this. They'll say, well, whatever I want, I do not want this particular cousin to get my estate. Mm-hmm. But that cousin will get your estate down the line if you don't specify. So those are important things too. Mm-hmm. So the proper way to do this is to make sure that everything is connected to the trust. So you have your house owned by the trust, you connect, everything by beneficiary designation or otherwise. And there are very important tax rules that must be discussed with the attorney, especially we're getting retirement plans and trusts. So those are something that you should really discuss with your attorney. So some of this stuff is very complex, but somebody who is very well qualified will be able to talk about those things as well with you. But think about this. If this seems like a lot of work now, it is so much better to be doing this now when you are feeling good and you're in you're yourself, you're in your right mind, and you're able to really control how things go. You don't want to have unintended things happening later. And then I just wanted to bring up, one other thing to talk about. When we talk about, the financial component, which is the trustee, the executor, the power of attorney, those are really important. But I also like to think about, talk about the health component, because it is, equally important to also plan for what if you're not able to make your own decisions, and what if, you have to have someone make medical decisions for you. And that's where Hipaa authorizations come in. Hipaa is the law that governs who exactly is able to have access to your private and protected health information. And you want to make sure that your loved ones are properly named in a proper document under HIPAA, so that, God forbid, something happens and somebody is having to make decisions for you, they are able to have full access to all that important medical information. And then the other thing to think about is what we call a healthcare advanced directive, healthcare power of attorney. Those are the directives that allow you to appoint somebody to make health decisions for you if you're unable. So again, a lot of times think about these things in terms of end of life, who's going to pull the plug and all those things. It's important to think about that stuff. That's really important. But also think about, you have a brain injury and you're incapacitated for 20 years. And somebody is going to be caring for your, making sure you have a caregiver, making sure your doctors are right. Do you have this surgery or not? When does your podiatrist come? I mean, imagine like all of these little, decisions that have to be made. So it's really important to think about this stuff in terms of not just the short term, but also the long term. And so it's really important to just name people that can make those decisions for you.
Yeah. So Lisa, how important is it that if a parent has one child, do they still also get a trust?
Oh yeah. Thank you so much, Doctor, for bringing that up, because that's really important, because there's an added layer of complexity and importance with children. And that's because children under the age of 18 or people under the age of 18 are not able to inherit assets directly. And so what happens is we have to have an additional court proceeding known as a guardianship. And that first of all, it's expensive, because now what we do is we have court fees and attorney fees every single year until the child turns 18, or children, right? And the second component of this is, once if that does happen and you have that court guardianship on that child, then once that child turns 18, on that child's 18th birthday, they can go into the bank or wherever the money is held, get a check and go, have fun with it without any regulation by anybody. Whereas if you structure it in a trust, what happens is we can say, what age do you think it's appropriate that your child would have control over his or her assets? So these are all things that I think most people think are really, really important. And when you do a trust, we can make sure that you are able to structure those things. And I might also add that it's very affordable too.
Okay, Lisa, we're going to take a break and we're going to come back later with some more questions for you. But when we come back, we're going to come back with Ms. Mary Greene, who's going to talk to us about insurance and long-term care.
Thank you so much, guys. It was a pleasure. Thank you.
We'll be right back.
Thank you.
I don't want to talk about it.
I don't want to talk about it.
Families don't have to talk about everything, but they should talk about how to plan for an emergency. Get tips and resources to make your family's emergency plan.
Well, we're back for the second half of the show. We have Miss Mary K. Greene joining us, who's going to talk to us about the importance of having insurance and long-term care. Miss Mary Greene, who's a financial advisor for Prudential. Mary? Where's Mary?
Hello, how are you?
Hello, Mary.
All righty.
Hello, how are you? Good evening, everyone. How are you?
Good.
Everybody
Great.
good? Good.
Tell us why it's important that we should have an insurance policy so people will have some money to bury themselves and take care of whatever other necessary things that they need without putting a burden on the rest of us.
Okay, great. First of all, I want to thank you and Dr. Vanessa for having me on the show this evening and allowing me to just share some really good points as it relates to life insurance. So the first thing that I want to talk about is that typically in the African American community, a lot of our community buy what is called burial policy. There's a big difference having a life insurance. So let's talk about the two and what is the difference. So burial policies do exactly that. They bury you. They are very small face amounts, typically 10, 15,000, maybe 20,000. And what they normally will do is that you'll have an insurance policy to go to the funeral home. They'll confirm that amount of that policy, and there's just enough to pay all of the burial cost, and there's nothing left over for the family to have to pay off any other expenses that may be needed to be paid off. So typically we see that a lot. Now, if you're planning to leave a legacy, this is where life insurance comes in. Life insurance, typically much larger amount of face amount in terms of the death benefits. And that will allow your family to take care of any of the other expenses they may have after the death of a loved one. So if you're asking me, which one is better, I will tell you this. Having a burial policy, something is better than nothing at all. So let's establish that. Yeah. But if you want to really do your family a big favor, if you want to show them how much you love them, then you will buy life insurance. And so what is life insurance? Life insurance is a contract. It's a contract between the insurance company and the person who is insured in that contract. It's for a specified amount of benefits, death benefits that will be paid out, upon the death of a loved one. And typically there is an offer. So the insurance company will offer to insure that person. And the acceptance is that they make those payments either on time every month, or they'll make them how often they have established with that contract. So it's very important that not only did you get an insurance policy, but you need to have it enforced when you pass away, because it's just like your car insurance. It's only as good as a policy that you have enforced when there is a loss that happens. People don't mind insuring their cars, their houses, but when you start talking about life insurance, nobody wants to insure the most valuable person in the life of their family, which is them, And so we have to make sure that we make ourselves the priority. We can replace the car, we can replace the house, we can replace all those other material things, but we have to have life insurance so that our families will be able to take care of the things that they need to take care of in the event of a premature death. It is not a question of if we are going to die, it is a question of when we are going to die. Exactly. We are seeing a lot of things going on here with COVID. So I would encourage, our listening audience that if they haven't had a chance to sit down and just kind of review what their life insurance options are and make sure their coverages are in full effect and they are exactly what you want your family to have, I will suggest that our viewing audience and our listening audience, that they take the time to do that. Mm-hmm. So what are some of the things that life insurance can do in the event of a premature death? So one of the things that the number one reason that individuals buy life insurance, and they buy to replace their income. As you all know, when there is a premature death, and especially with someone who's in their earning years, what happens is that check coming into the household, If you have small kids or if you have a mortgage and there's income that still needs to carry on, life insurance will replace the income. Second, pay final expenses. When you go to the funeral home, there's a couple things that will happen. Either you'll take an insurance policy in there, or somebody better take a credit card, or they better a checkbook, because the funeral homes, they're not going to do any work. They're not going to even look at the body. Good. They're not going to even talk to the family unless there is an insurance, unless you can, provide proof of funds. So checkbook, credit card, cash, insurance policy. Somebody going to have to be responsible for that funeral bill. And so it's a lot easier when you have an insurance policy, because they can call the insurance company and confirm that that policy is in full effect and how much the value of the face amount is. Third thing is estate planning. You just talked about, with Lisa, trust and wills. And this is where life insurance can come in, because that is a great way to leave a legacy to your family. Sometimes you don't have to be the richest person in the world. You just have to be one of the smartest person, because you can create your own legacy, multi-million-dollar legacy, using life insurance for pennies on the dollar. We've had life insurance when someone passed away, put kids through college. I remember early on in my career, 50-some years old, he was working. He passed away. He left his wife quite a bit of money, and then I took the check over to her, and they had 2 kids in college, in the middle of college. But those children were able to go ahead and finish college because their dad left them enough money to be able to do so. Next thing, pay off debts. Your family, if you don't have any type of life insurance and you are the sole breadwinner of that family, doesn't mean if you're a husband or a single mom with kids, but if you pass away with no life insurance, their lifestyle is going to change, absolutely going to change. Why? Because if you don't have any life insurance to pay the mortgage, or enough money for them to be able to pay the mortgage in full, or pay it every single month, they're going to have to move out of that house, because they may have needed both of those incomes to keep that household going. And with one income, now that family's lifestyle is going to change. And so you have to think about, if I left here tomorrow, would my family have enough money to pay the mortgage, to put food on the table, to be able to, send the kids on to college and do all the things that you would like for them to do and plan for them to do if you were still there. So life insurance will allow you to do that. The death benefit for life insurance is tax-free. So here's the deal. If you buy a policy for $100, yes, it is. If you buy a policy for $100,000, it is. Most people don't know that, but the death benefits are tax-free. So if I buy a life insurance policy for $1 million, leave it for my family as part of my estate, my family is going to be paid out $1 million. Okay. So this is one of the very, very few things that is not taxable. If you leave your family $2.5 million in death benefit, your family will receive $2.5 million tax-free in cash. So I want to stress the importance of the proper planning when you are sitting down and trying to figure out how much insurance do I need. There's 2 types of insurance. There's different options and different riders out there that you can have as part of your insurance planning. And the best way to have that discussion about what your needs are, what would you like to do, is to sit down with a good financial advisor like myself, or someone in your community that you trust, and have that conversation with them about what you would like to happen for your family in the event that you're not, that something happens to you when you're not here. Not if you're not here, is the question of when you're not here, from that particular perspective. And then Lisa and I work together.
Mary, let me ask this question. Not
Go ahead.
But I need to know this. I mean, well, they need to know this, just not me. You were saying that in insurance policy, we should look at it. Okay, take out enough insurance money to bury yourself, or either take it out separately. So, when you go to the funeral home, they will sit there and name everything that you should take, so you can walk out of there spending $15,000 and $20,000 if you listen to the funeral home. So, how much would you say that you would need to take out just to have an average burial? Because because people are walking around with no insurance because they say they don't have money to take out an insurance policy. So, what is like a low amount you would say you would have enough to bury yourself? And then we can add on some extra money, for family bills or to take care of the family when we are going.
Well, we average, when we start planning for final expenses and we're sitting with a client, let's say if I was sitting with Dr. Vanessa, I would probably say that I would plan the budget between $10,000 and $15,000. Because insurance is not about the future, it's about today. Yeah, we hope people will live, longer. But what if, Dr. Vanessa doesn't come home tomorrow? What if she doesn't come home today? So we look at it today. So we look at it, the average cost of a funeral today, you can spend between, $10,000 to $15,000. And I'm going to tell you, I've had the experience of working, with a family in a funeral home. You get a chance to tell them, all the things that you would like to be able to do, during those final arrangements, So you have to look at it and say, what makes sense for me to spend and what doesn't make sense to spend. But the average cost right now is between $10,000 to $15,000. That's what I would, plan for if I was a family. If you're my family, I told them they better not even spend that much money. I would like to be, put away as least expensive as I possibly can and enjoy my money some other way. But that's me.
Well, when we come back, I know we're ending. I just want to want you to add on, why is it important to have a long-term care rider when individuals get sick?
Sure.
It becomes a financial burden on the family.
Yeah. Well, we're going to thank you for joining us for the show today. Our time is up for our show today, so we want to thank Mary and Lisa for joining us, and I hope you got some information from them of what you should do. If you didn't, you had their phone numbers, you can write it down. You can always get in touch with them later to discuss whatever it is that you need to discuss. But if you want to hear more, stay around for our after show, and we're coming back with that in a few minutes. So take care. Thanks for watching today. And as always, we'll see you next time.
Thank you so much.
Good night, everyone.
Thank you.
Thank you. Night, everything.
Today's show is sponsored by Abu's Bakery. If you have a sweet tooth, stop by Abu's Bakery for some delicious cakes and pies. It's Shannon. It's Shannon. It's Shannon. It's Shannon.
Hi, we're back for our after show, and we had a lot of information on the show at the beginning. And Lisa took us to the steps of why we should have a trust fund. That was good information that we need to know. Which, Lisa, I still got to ask you another question about that. But I know when we ended the show, Dr. Vanessa, you had asked Mary a question, so we want to have her to answer that, and then I'll get back to Lisa with the question I have for her. So, Vanessa, if you want to repeat the question again.
Yes, I was concerned that sometimes when people get sick and they're much older, it becomes a burden on the family to take care of them when they're home, or to pay somebody, to take care of them. So how important is a long-term care rider, which a lot of people I've spoken to don't have an idea what that is. They don't have a clue what that is.
Mm-hmm. Well, the importance of it is there's riders. The thing about life insurance today is that there's a lot of different, what we call riders or different enhancements that you can put onto your life insurance policy. And, or you can, buy what we call strictly a long-term care policy. And so there's riders out there, they're chronic illness riders is what they call. And what they will do is that they'll enable you to accelerate your death benefit and turn it into more of a living benefit, where you could take some of your death benefits and you can take it over a period of time and you can pay for someone to come in and provide care for you while you're still living, and still be able to have some money to pay, death benefit at the end. And so why is that important? Because it does allow you to, remain in your house, and most caregiving is done by a family member. So it does allow you to have a family member come in and to be able to take care of you, from that particular standpoint. And now they're able to have some type of income, probably coming in while they're still caring for that particular family member, is what it does. Mm-hmm.
So Barry, do you take this out when you take out the insurance policy, or if you already have an insurance policy? Is this something you add on to the insurance policy that you have? How does that work?
No, if you have an
you add it on now, or
if you have an existing, yeah. Well, what it is a couple things. I'm not allowed by law to say it's long-term care, so I have to say it's a chronic illness rider, and you can use it, to pay for care in the event that you have a chronic illness like diabetes, kidney disease, you've had a heart attack, you've got cancer. And so so that's why I have to call it the chronic illness rider. Yeah. Okay. But people use it to pay for care in the event they have a chronic illness that requires them to need someone to care for them. So two things. One, if you have an existing policy, you cannot add it to it because that's a standalone contract. So it's only available on the newer contracts. Okay. And the second thing of it is also too is that it's easier to qualify for it with your life insurance because the underwriting restrictions on long-term care, on a standalone long-term care policy, it is pretty, what I would say, probably pretty difficult in today's environment. And so that, provides, because long-term care insurance has gotten very expensive. And it's very hard to qualify now. So what now is people are looking at different alternatives in which they can, have at their disposal to kind of offset some of those costs as they look further down the road and into the future. So some of the same requirements, but just a little bit more easier in terms of the underwriting process. It is a rider, so you have to get a new life insurance contract and make sure that rider is available on it. And then again, the underwriting requirements, you'll go through the life insurance underwriting versus long-term care underwriting, which is a little bit easier. Okay.
Now, Lisa, I have this question about the trust, fund again. You had said before about the children, if you have children. Okay, so if you only have one, so this one really don't have to really fight with anybody, but is it still good to set it up even though you only have one child? One question. The second question is, okay, suppose you don't want to leave it to that child, you want to leave it to the grandchild.
Oh, sure.
Underage. How does that work?
Yeah, so that's what's perfect about a trust is because it allows you to leave your assets, your life insurance, your estate to an underage child. So that could be your own child, that could be a grandchild, that could be anybody. And that's the beauty of this is that you get to decide how you want to have that structured. So it is absolutely important to do it whether you have one child or if you have no children, and or if you have grandchildren you want to take care of. So the way the trust works is the trust will allow it outside of court to leave it to, your grandchild, your child, whomever it is who's underage. And what you do is, remember how we talked about the financial people, that's going to be your trustee, your executor, your power of attorney, whoever that trusted person is, that person you really trust with everything, who will take care of your affairs, that person would be the person who is able to supervise distributions to your underage child, grandchild, whomever, nephew, niece, whomever it is in your life, until they're an age that you decide is appropriate. So if you think 25 is appropriate, then the child or the grandchild still gets those funds before that age. It's just that they have to discuss it with and coordinate with your trusted person who, would be your trustee. Does that make sense? So
yeah, but what I'm trying to get clarification on, I understand what you're saying, but I just want to make sure I'm clear. Okay, so it's your child, but then you have the grandchild. So if you leave it to the grandchild, so now you're gonna put down the mother's name, who is your child and daughter. You're gonna put down that person's name who has to oversee the trust for the grandchild. So do you have to put in the trust like at stages of how old the child is as to whether they get this amount of money, or where, say when they get say God forbid if something happened when they real young, do you put like, okay, when they become 15 they might get a certain amount of money, okay, when they become 18 or 20 they get another certain amount of money, and then like that? So do you have to put it in the trust for the mother to know that, okay, this is when you can give that grandchild what you have, and then if you have property, then the property goes to the child when they become a certain age, they can handle the property?
So the answer to that is we don't generally put ages for when somebody gets property or gets money now. And the reason for that is because if the child has an absolute right to get it, so does everybody else who might be coming after the child. So if the child's going through a divorce or is sued or any number of things. So instead, what we like to do is, and keep in mind that you can choose whomever it is who would be in charge of that money pretend it's the grandchild, as you said. You don't have to name the grandchild's mother. You could name anybody in your life to supervise that. And so instead, what we're really talking about is who has the power and control to supervise. So it's more about at what age is the child able to be in charge, okay? And so we don't say Johnny gets, 1/3 of my estate at age 22, because what if Johnny is in a car crash and, he made a mistake and now somebody's suing him for everything he has? The fact that that's written in there that says Johnny gets this absolutely means so does the person suing him. In most jurisdictions, that's the way the law will generally interpret it. I have to just add a caveat that, I can't guarantee that.
Okay.
So we're worried about law, the courts interpreting it that way. So instead, what we say is, marry your trusted person, whomever that person is. It could be your best friend, right? It could be your sister. It could be whomever in your life is going to be in charge of saying yes or no to distributions to Johnny, our grandchild, right? And so that is really important, because if somebody's suing Johnny in general, right? If somebody's suing Johnny, or if Johnny's having a hard time or whatever's going on, that person is a little bit better able to protect those trust assets in general without guaranteeing anything. But we can't guarantee things, but we can say that we do know it's much more effective to protect the principle of your estate and protect what you have by not giving an absolute right to a person at a particular age. Because, it's kind of like you say, oh, yes, age 22 or 25 or 27. Who knows what's happening in the life of that person at that time. Okay. And so, but the key to this is you must really trust your trusted person, your trustee, because that person is going to have a tremendous amount of power. But I also want to add that the trust that our office does has built-in protections. So there's mediation protections and other things in there so that we can have a checks and balances, so that we make sure that your trustee must honor the terms of your trust, because they do have a lot of power, the trustee does. But however, we also provide protections for the beneficiaries. So we make sure if a beneficiary has a concern that there's a way to address that without having to go to court, which is very expensive. So there's a lot in there but I hope that answered your question. So it's more about when is there control for the child to be able to stand up and say, I want this now. That's what everybody who does this gets to decide, and every person is different, Yeah. So.
Well, that's true too, because you can't. Sometimes you can't trust the family person you put into it.
Right. I want to add one more thing. I kind of said something at the end. This is very affordable. So just at least I can speak on behalf of our office. Everything is based on a flat fee, and it's known upfront where that is. And we do offer also discounts, especially in times of need. So I would encourage anybody who would like to set this up that you should not be feeling like you're not able to do so because of cost, because we will work with anybody. The most important thing I think for us is that we protect legacies and we protect people and their assets, and make sure that, a good plan's in place so that, even if the person is physically left the earth, their loved ones feel the love after, with that smooth transition and that protection, is, like what Mary was saying. And so, just know that this is very affordable. It's certainly much cheaper than going through a court process. And we'll also work with anybody, especially during this difficult time of the coronavirus. So never feel like this is something I can't afford or something I can't do, And
so, Mary, let me ask you a question. When you take out an insurance policy, right, and you have two people named on the policy as beneficiaries, right? So when that person transition, now suppose you can't find the other beneficiary that's on the policy. Now, do all the money comes to you?
No, it does not. It will go into what we call unclaimed property. Well, we'll do everything we can to find that person, and then we put it into what our suspense, portion. And then after a while, we have to notify the state that we have unclaimed property and that we can't find this individual, and it stays out there until that person comes and claims it. But we make every reasonable. But two things that you have to understand. And when you are designating beneficiaries, we always ask for that in writing. And if there's a change, we will ask for a beneficiary in writing as well. So that's the first thing. And the second thing of it is whoever you have as your beneficiaries at the time of the death, that's who we're paying out. So that's why we encourage all of our clients every year, to sit down and to make sure that you have beneficiaries properly indicated on all of your valuables, not just your life insurance, on your retirement accounts, on your investment accounts. Everything that you have should have a beneficiary on it. Because if not, I can tell you there are implications, severe implications. And if it's paid to the estate, depending upon the type of account it is, there's severe taxes, that can be incurred, and there's repercussions. Lisa and I worked on a case a couple of years ago. We were able to get it turned around, but when you're changing jobs and you got an old 401k, when you got an IRA, when you got a Roth IRA, when you've got bank accounts and things of that nature, you need to make sure that you have designated beneficiaries on those, because again, the whole thing that you want to do is avoid probate and avoid unnecessary taxes on your estate, because it reduces the amount of money that your family members are going to get. If you got married, if you got divorced, if you had kids, if somebody died, those are all life-changing events. So you need to make sure that you go through and make sure all of your beneficiaries are up to date on everything entitled to and is of value to you. That's the best thing I can tell you.
Absolutely. Wait a minute, I'm not following you. I mean, when you say pay the taxes and there's consequences, so if you have a beneficiary listed, right? So I don't understand. What are you saying? Like, if you don't have someone listed, or it's not the person,
right? If you
wanted,
if you don't, well, you think
the person you didn't want listed, because you have to list what you want. So if their name is down there, so how does that come in about them paying taxes and stuff?
Well, there's a couple of things. One, you want to name beneficiaries on your property, on whatever you have. So you want to have a name. If, let's say, for instance, you passed away and there is no beneficiaries listed, hypothetically on your, IRA account, then they can, through probate, and it can be paid to the estate, and then the estate is taxed a little bit different than an individual can be taxed, is what it is. And but as long as you've got beneficiaries designated, we're going to pay beneficiaries. So all I'm just saying is make sure that the people who have designated beneficiaries are the people that you want us to be paid. So one, I need to have a beneficiary named on all of my valuables, my accounts. That's first thing. And second thing, the name that's on it, just make sure that it's the person that I want to receive those, those proceeds, whether it's from an insurance policy, whether it's from an IRA, your 401k, but make sure the person that you want is on there, because once it's paid, they're not going to go back and reverse it. We're not going to go back and say,
so Mary,
yes.
I'm sorry, I got all these questions, Mary. Now, if you don't have someone's name down there, right? So you said it goes to the state, right? So now
it's going to be paid to the state.
Huh?
It's going to be paid to the estate.
Right. So when it goes to the estate, right? Exactly. So now the state, doesn't the state has to have somebody's name down there? So how do you find out who's next in charge that will take care of the state to make sure the next part of the family or the next family member in charge would get the money? How would they know?
Then it goes through probate. They're going to go through probate. They got to go through the course, and they're going to go through probate.
So that's what I'm saying. So somebody in the family has to come forward to say, I want to be in charge of this.
Yeah, Lisa can answer that, but Lisa is going to go through probate.
Yeah, I can help a little bit. I can help out a little bit on some of the more legal or tax questions on that. Shannon, if you want. Mary, if you're okay with me.
Yeah, go ahead and let her know that they.
Yeah, no, these are. So let's talk first of all. Mary is absolutely correct. If you have, we can call it a failure of beneficiaries, or for whatever reason, you don't have a beneficiary designated on. Especially, let's talk about IRAs, 401ks, any type of pension, what we would call qualified asset. Okay, so the way that works is, depending on the value of that asset, how big it is. The probate court will get jurisdiction, and those numbers are determined state by state. In Illinois, it's $100,000. Each state is different, but they're different, but they're similar, so they're pretty close most of the time. But the big deal is, here is where it becomes really catastrophic if you don't have your beneficiary named on that retirement or qualified asset. Okay, is the estate has only one option for distributing that retirement account, and that is a lump sum distribution, which means if you have a $100,000 401k IRA, any qualified asset, and somehow we thought someone was on there, but they weren't, and so the estate is the beneficiary, that means that that's a lump sum. There's no choice. There's no, I'm sorry, I thought this was, it's just no choice. So that is income. That means it's $100,000 of income coming into the estate. So then you might say, well, who cares? That's just the estate. But the estate is, it can be taxed two ways. It either flows through to the beneficiaries, and the beneficiaries pay income taxes, and that's mostly how it happens. Pay income tax on that. So can you imagine the gift to your loved one is $100,000 in income? So you're giving them $100,000 retirement account, and they're having to give, a third or a half of it away to the government. Can you imagine? That's terrible. That's completely avoidable. The second thing, to answer your question, Shannon, about so when you go through probate, what happens is, if there's no will, where that you have established who your legatees or beneficiaries are going to be, what happens is the state law says who it's going to be. And it may be people you want, it may be people you don't want, it may be people who are disabled. I recently had a situation where, unfortunately, we had a woman who was not married. She had no children. She had siblings. She passed, and she had no will or anything, and so she left her assets to her. Of course, her siblings were heirs, and that's what the law in Illinois said, was that for this particular woman who passed, her siblings were her heirs of her estate. Okay, that doesn't sound so bad, right? Except one of them was an adult woman with Down syndrome, living in a nursing home on Medicaid. And guess where, I mean, her inheritance is essentially now going to be a problem that's going to cause all sorts of problems with her qualification for Medicaid and all. Now, this was completely avoidable. And I'm not, God rest this woman's soul who passed, you know, I'm just saying it's not, but I'm just saying, literally, had advanced planning been done, we wouldn't have been faced with the choices with not only an extremely expensive court proceeding, but also having to deal with worries about, is this beloved sister going to still qualify for Medicaid for her home? And what if she's disqualified? She'll have to apply again after all that money is spent, of course, on the home. But then is she going to get the same benefits that she had before, because this particular person had benefits for a long time? And so if you lose them, are you going to get them back at the same level, the same, you know, so there's all sorts. So that is a good example. So just imagine $100,000, giving half of or a third of it or half of it away, right, to the government for taxes, and then turning around and if you have an underage person or you have a disabled person, you're going to give another good portion of that away to court costs and other costs and maybe interfere. So I didn't want to go too long, but I'm just saying that's by not naming, you know, taking the time to name and taking the time to check. And that's where Mary and I, we work together a lot. And we're a good team. I love working with Mary because we go through and we double check and triple check all that stuff when we're working together on this stuff. So, you know,
could you give an example of when someone can contest your will? Like how you know, because I thought when you did a will, I didn't think it could be contested. Could you give an example like when someone can come in and contest your will?
Yeah, so let me just clarify one thing. Yes, that I can. First of all, let me say that when you do a trust, there's no contest clauses that it can be put in a trust. Right. You know, there are exceptions for if somebody was actually under undue influence, if they were, you know, we always have to protect the person who's signing. So we want to make sure everybody has capacity and so forth. But there are some protections in place regarding contesting a trust. It's generally, we're trying to discourage that as much as we can. When you have a will, though, think about this. That's going through a court proceeding. And the court has a very, very important public policy interest. And that is making sure that all of the heirs to an estate are informed of their rights, both as heir, you know, blood relative or, you know, of the deceased, but also that, you know, they have a right to contest if they want to. And so the big difference between probate with a will is there is an absolute procedure in place where you have so much time that if you find out there's a probate proceeding and you want to contest this will, you can. And that is built right in. And it's not anything that we should think is bad in the sense that you understand the courts have a very important interest of ensuring the validity of the process. They have to make sure that they do find all the heirs. They have to make sure that, you know, that we're not leaving somebody out. And so that is just part of the normal process that our courts follow. The difference with a trust is that we don't have that process in place because we're deciding now in this agreement, you know, here's who I'm going to leave my estate to. Right. And so we don't have that in place. But when you go through the court system, it is a very important part of that court system to ensure that we have everybody that's supposed to be there. So absolutely. So that's why. That's the big difference between a will and a trust and going through court and not going through court.
But you know, just looking at what happened to show you how important it is to have what you said, either trust or will or whatever. I was thinking while you're talking, I'm going back to when Prince passed away.
Yes,
will. So everybody was fighting. So the nieces, the nephews, any kind of cousins was coming out of the woodwork, talking about, well, they was a part of the family. That's one. And when Aretha died, and then her boyfriend, because they had been together so long, he felt like that he should have a part in there because, you know, I think they had been together like 25 or 30 years, which I couldn't figure out why she didn't put him in there, because if that's your partner and you've been together that long, he's expecting something because he helped take care of you. But when things like that happen, it's like, it's unbelievable that you didn't have this in place and how people can just, You don't come in and say, well, I should get this, I should get that, and then they don't get anything.
Right. So the big thing is when you have a public court proceeding, there are certain notifications that have to be sent, that have to be addressed, even publications to creditors. So we have to send out notices to, hey, here's John Smith's estate. John Smith passed. Here's his probate court number. Hey, any creditors of John Smith? Anybody who wants to get a bill paid, we must send that out. That's part of the process. Whereas when you have a trust, now I must say the trust must, of course, honor obligations and follow the rules and, pay all the taxes and expenses that are due. But the trust, the main requirement and the main concern for the trustee of the trust is going to be, here's what the trust says, here's who's inheriting under the trust, and that's what I'm going to follow, And so it doesn't have the same focus that a court proceeding has, where the judge is thinking, I've got to worry about, are these all the errors? I've got to worry about if somebody's saying this isn't fair, there's a statutory right under the law where they are allowed to make their case. These are all very important considerations and a very important function of our courts. So we get to choose, we get to say, do we want to put our estate through the court system? And if so, we get to choose, and we do that by way of not planning or by way of a will. But if you want to have it out of that court process, that's where we do a trust, and you work with a qualified attorney with a trust, and you follow certain steps. And then you're able to kind of take it out of that mandatory system and have it in on your own terms.
Okay, so Lisa, so is it that a creditor, someone can add a claim onto a will? Can they add a claim onto a trust?
Yes, it's slightly, yes. So I must say the trust must pay bills and expenses of the estate. Of course, that's true. But a trust is more private. So, all the assets are publicly known with a will, and, you have inventory and accountings and reports sent. So everything's kind of out in the open. Whereas with a trust, it's private. Maybe you have a little more negotiating power with the creditor because the creditor doesn't know what you all have there. You're able to talk with the creditor and perhaps negotiate some of that down in a way that you wouldn't, and you must always honor all obligations. But the difference is when you have an estate that's public record, you've got literally every last thing you've got out in the open for everybody to see, right? With a trust, you can say, I'm the trustee of the trust. I'm going to review your bill and decide if I'm going to pay your bill. And if we owe it, we have to pay it. But I'm going to tell you, this is how much we're comfortable paying. You have more negotiating power with a trust, in general. So that's really, it's not that you don't have to pay the bills. It's more just imagine we've got one scenario where the creditor's like, okay, so they have this and they have this and they have this and they have this versus, hello, you're talking to the trustee, and I'll tell you what we're willing to pay. So that's sort of the difference.
Alrighty. Thank you.
Thank you.
Well, thank you, ladies. Listen, whoever's watching, let me tell you, you better pay attention, listen to what Mary and Lisa told you to do, because trust me, I've lived through experiences through my own family of fighting going on over stuff that if it had been put in on a piece of paper, they wouldn't have to go through all of this. So trust me, it's important to get a will. Whatever you have, lamp, TV, whatever, just put it in the will. So this way there won't be any problem when you pass on and they read the will to say what you get and what you don't get or whatever. Thank you, ladies. This has been really, really informative. I mean, I have so many other questions, but we're going to have to come back to this again and stuff. But I thank you for coming on tonight. I thank you for joining us.
Thank
and
you.
I think that's
thank
bring
you.
you on. And
Thank you, ladies.
You'll come back again so we can finish our other questions. You'll come back. So thank you for joining us again.
Yes.
And
Thank you. Thank you. Thank you so much. Thank you, ladies.
Bye-bye.
Bye. Bye.
Today's show is sponsored by Abu's Bakery. If you have a sweet tooth, stop by Abu's Bakery for some delicious cakes and pies.